just an unfortunate situation. What is NL's, have they given an official response? What's their statements?
Of course, they're continuing to fight this all the way. And I don't know whether they're
Yeah.
getting bad legal counsel or whether they're getting counsel and they're just stubborn. But, they push back. And I think their initial reaction after the December hearing was, we think we're appealing this. We think this is a bad decision. It's going to hurt the school district. It's going to hurt everybody. We don't think we should have to do this. I don't think it's going anywhere. The original decision has been appealed and has already been appealed and has been rejected for a review by the Supreme Court. So I don't think they're gonna. I don't
So
think they're gonna win.
it's gonna end there.
There's
Well, they've
one
had
other.
been a
There's one.
10-year battle, right?
It's been a 10-year battle, and I mean this isn't going to probably be completely resolved here for another few years. But I think the Indians are probably going to prevail.
So many. It's a twisted web of a
Yeah.
story. It really is.
Yeah, one other thing that I uncovered while researching this was there's some NEPA considerations here, which National Environmental Policy Act aspects, which I have not seen reported anywhere else by any of the other people who are covering this story. But as you guys know, if you're working on federal property or any kind of property that has a federal nexus, then you have to comply with the National Environmental Protection Act. And I have confirmed with the Bureau of Indian Affairs in Oklahoma that in order to do a mining project in Osage County, you have to do a NEPA review. You have to do an archaeological review. You have to do an environmental assessment like we do with oil and gas to see if there's Indian artifacts, if there's burial sites, if there's cultural sites, all those sorts of things that we deal with in the oil and gas business. The wind industry, I mean, would have to do that if they were operating on federal property. They also have to do it if they're mining rock.
They're gonna mine. Yeah.
If they're going to mine.
By virtue of that defined mining operation, they back into requirements there that they've also violated.
Yep. So the Bureau of Indian Affairs has confirmed that they should have done a NEPA review. Now, not doing a NEPA review or not doing an environmental assessment on a federal tract is a serious issue. And I think NL's position is, well, we didn't think that we were mining because they've always taken the position they weren't mining. They were just digging up rock and using it to build the wind farm. And they said that's not mining. But the courts have now determined it is mining. And so if it's mining, then they needed a NEPA review and an environmental assessment, and that hasn't happened. So I think they could be under some pretty serious trouble with the federal government for failure to comply with NEPA.
Is that a common practice for other wind developers to mine rock now that we know that it's mining and use that for their projects? And what does that do to other wind farms that are out there?
I have talked to a number of people about this, and I think this is the answer I've gotten, is that sometimes you do use the rock that you've dug up, but you always have an agreement with whoever the owner of the minerals is. So if the surface and the mineral owner are the same, you're just dealing with the same person when you buy the surface lease. And then there are other cases, like in this case, if the rock is not suitable for the need for, it's not the right type of rock that you need, then you bring in material from an outside source and you bring in concrete
from wherever.
Yeah. But you guys do a lot of renewable work. So what's been your experience?
Well, it's typically it's handled as a part of, you have waiver and joinder by the mineral estate in your efforts as a part of your insurability for the project. And, it's back in the mid 2000s that we were doing a lot of this wind work, and it still goes. It's not as prevalent today as it was back then. But yes, I mean, common practice, you secure rights from the mineral estate if you're going to mine or do anything to that effect. I think it's not something we dealt with commonly, right? It tends to work itself out by purchasing material and all the things that you need to do for construction. It's my question is, in the court proceedings and in the rulings and whatnot, did the court specifically kind of opine as to if they would have taken the rock that was used in the construction of their pad, just that rock, the 60-foot circle or whatever it may be, and use that material in any way, would that have been in violation? Or was it strictly because they went outside of that construction site, open pit mined an area? Is that what triggered it?
I think it's a little complicated. Clearly, if they went outside the foundation and opened a rock quarry there, that's
Yeah,
clearly
it's pretty
a circumstance.
black and white there.
I think if they had taken the rock out of the hole, piled it on the side, put in the concrete foundation, and then filled in the hole with rock, and just took the old rock and filled it in, that would have been fine. You took the rock out and you put it back in. What constituted the mining was the fact that they did not want to use the rock in its current condition. They wanted to load it on a truck, take it to a refining company, crush it, refine it, sort it into commercial materials that would be typically what you do if you're mining rock. You take the raw rock and you make it into commercial grade material through all this processing. So the fact that they processed it before they used it is what constituted. So even if they had not opened pit quarries outside of the foundation, they
still made commercial use of it.
They still made commercial use of it. Yeah.